one, I'm very happy and very relieved by this judgment. Uh, Always never in favor of the right of states to be deprived of right to indirect taxes. So that was the biggest thing. Now, with this directive of the Supreme Court, I hope things are brought back into focus, and I hope the working goes to that level. There would be two aspects of taxation. One would be the rate of taxation. If you want a common rate of taxation throughout the country, I would have a little objection to that. Because earlier we had tax havens where certain states were undercutting other states in taxation, and people were going there. I myself bought a vehicle from Goa, for example. My vehicle was registered in Goa just to test the rate of taxation. It was much lower there. So that is fine. But the right to the revenue of the state government, which it was enjoying through the VAT regime, that must not be taken away. So I am very happy and very relieved that the Supreme Court has taken a call on the very federal structure of this country. Now, if you see a couple of points that the Honorable Judge has enumerated, you mentioned about harmonious decisions or consensual decisions. Those were the initial days when Mr. Jaitley was the chairperson of the council. At that point in time, I remember quite well, and with a lot of pleasant surprise, that not one issue did he push through if even one state was not on board. There was no question of voting. His way of dealing with the situation was very mature and very equitable. And even if one state was showing disagreement, he would not allow a decision to be passed. Lately, though you mentioned that very few decisions have been taken through voting, the sense of the House is of a majoritarianism. It appears as if decisions have already been taken in advance, and those decisions have been brought into, as a formality, into the GST Council with the presumption that this is something that is to happen. This will happen. This will get passed. So that sense which has come into the GST Council of late, that was extremely unhealthy. There was no scope for the federal nature of this constitution of this country to sustain. If you don't have right to resources, what is your independence? What is the federal nature of your polity? It vanishes. And the other thing, if you see the voting right, which the Supreme Court has also talked about, the 1/3 and 2/3. 1/3 lies with the center, 2/3 lies collectively with all the states. Now, if a decision is to be passed by a 75% vote, not one decision can be passed without the consent of the central government. So everything is in the court of the central government. If they want, only then it will happen. If they don't want, it will never happen. So the federal, so to say, constitutional independence of the states was completely abrogated by this GST regime. So whether it was during the UPA government's time or during the NDA government's time, I was never happy or comfortable, and I have always voiced my opinion on this, that the right to taxation, rate is another thing. Have a common rate throughout the country, I have no objection on that. But the right to taxation must lie with the state government. That was very clear. And as far as the dual layer, the Supreme Court has enumerated Article 246A, where both Parliament and the state legislature have the right to legislate on indirect taxes. So that is what Mr. Tyagarajan also mentioned. You cannot go beyond that. Then you're going beyond the Constitution, the provision of the Constitution. So I'm very happy and relieved on that account. And further, many a time the Supreme Court in this judgment, Justice D.Y. Chandrachud and the other members of the bench, they have enumerated things like dual layer federalism is known as a layer cake. Now, federalism of a multi-layer kind will become a marble cake. So, see, the entire nature of the constitutional federal polity changes. When the constitution was read to hold, the union had been granted more powers, but the union and the state has simultaneous powers to legislate on GST. And the constitution does not envisage the repugnancy provision. So these are the things which have come out in today's judgment. And I, for one, and I hope there will be many, many, many such individuals in our country